Yeah.
Good evening. Welcome to the third annual Kirkland and Ellis Law Forum at Stanford Law School. This year's topic is national security regulation, another source of enterprise risk for tech companies. I'm Amanda Packel from the Rock Center for Corporate Governance, tonight's co-host. Before I introduce our panelists, I want to thank Kirkland and Ellis for its generous gift to support this annual forum intended to focus on emerging issues in business law. I also want to thank Jeremy Veet and Josh Zachariah, Kirkland partners from the San Francisco office, who have been helpful each year in coordinating the content planning for the event. We have three terrific panelists tonight, so I'll do very brief introductions and then let you hear from them. First, we're grateful to have a moderator from right here at Stanford Law School, uniquely qualified to discuss managing risk in tech companies. Before joining us in 2014, Doug Melamed was Senior Vice President and General Counsel of Intel Corporation. He now serves as Professor of the Practice of Law at Stanford, where, among other things, he teaches a course on advising clients in a global economy. Mario Mancuso is a partner and head of the International Trade and National Security Practice at Kirkland and Ellis. He has extensive experience as a national security and foreign affairs policy expert, having served as U.S. Undersecretary of Commerce for Industry and Security and Deputy Assistant Secretary of Defense, Special Operations and Combating Terrorism. He also has experience in combat operations as a forward deployed military officer. And Danya Perry is Deputy General Counsel, Global Chief of Compliance and Ethics, and Chief of Litigation at McAndrews and Forbes Incorporated. She previously served as Deputy Attorney General for the state of New York, investigating public corruption, and prior to that spent over a decade as an Assistant U.S. Attorney in the Southern District of New York, where she was Deputy Chief of the Criminal Division. One housekeeping point, we'll leave at least 15 minutes for questions from the audience at the end, and we ask that you come up to the standing microphones so that your questions can be captured on the recording. Thank you. Doug?
Thank you. We're just going to have a conversation here for a while and then I guess take questions. I want to start by asking Mario the following question. The statutes, the national security statutes, Trading with the Enemy Act or whatever, CFIUS, that we think of when we think of national security law, they've been on the books for a long while. Obviously, the world's getting a little more tense now than perhaps it was some years ago, but from a legal point of view, what's different? Why is this an emerging and important issue for the Rock Center to have a conference on?
Great, Doug, thank you. And just a quick thank you to the Rock Center for hosting us. You're right, I mean, the statutes have been around for a long time. In fact, some of them have been around since the age of the Cold War. And they're essentially, all of them, taken as a collective, try to administer a denial strategy. They say, whether it's export controls or sanctions, they try to restrict something. And the assumption, really the policy assumption behind all of them is that the United States has something that other people don't have. That's obviously an assumption that's been challenged in recent years. So the statutes are fairly old. But I think what's different now and why the risks are particularly acute for technology companies is how the U.S.'s security profile has changed, primarily since 9/11. Just as an interesting tidbit, we can get more into it as we discuss it. When I served as a member of the previous administration, I was a presidential appointee. And during my time at the Department of Defense, we had received a statutory request from Congress, something called the QDR, the Quadrennial Defense Review. Essentially, it's an instruction from Congress. It's a statutory instruction that goes to the Department of Defense. And the instruction sort of says to the Department of Defense, every 4 years, you need to look out 20 years, and you need to assess alternative security futures. And you have to ask yourself the question and respond to Congress, I'm paraphrasing, of course, is the United States Department of Defense, is the U.S. government more broadly organized, equipped, configured to address those alternative security futures? And in 2006, when we were there as part of a strategy team for the Department of Defense and RAND that essentially did the strategy work behind it. And the conclusion of that, one of the important conclusions of that is that when you looked out 20 years in 2006, most of the alternative security futures were security futures for which the two principal instruments of U.S. statecraft, historically, military force and diplomacy, were instruments that were ill-equipped to address those security futures. And when we looked at other instruments, these statutes, these regulations that had been on the book, we realized that in between those bookends of diplomacy and military force, the U.S. government had a nascent, although a bit old, national security regime that was better equipped in conjunction with other tools to address these future challenges. And so starting in about the mid-2000s, largely as a result of 9/11, prompting the national security establishment to sort of think about the world in a different way, but continuing today, and it's a secular trend, you find these statutes and regulatory regimes that are on the books, so to speak, they are more relevant today, just given the nature of the U.S.'s security profile, our likely security challenges, and where the tech industry fits into this is, there's more to it than this, but just given the nature of the business models, tech talent is global, right? It's not exclusively American. Markets are global, and many of the products, whether it's high-end encryption or other critical technologies, these are instrumental to the United States in terms of preserving fundamental military overmatch advantages. So for those reasons, in some way, the regulatory regimes are old, but the setting is new and increasingly important.
Is the difference, or maybe the focus of these kinds of regulations on preventing bad guys from getting assets that could help them, or is it more affirmative than that, not just defensive?
In terms of preserving, perhaps U.S. domestic industries, I think, I don't think it's the latter. I certainly think it's the former. I mean, for some of them, in some instances, the United States administers these legal regimes. I'll give you a practical example so we can get, crime control, export controls of categories. So you can't, for example, if you're a U.S. company, export certain batons, electronic prods to countries like the People's Republic of China. There are others, countries that the U.S. government has determined to be have policies inconsistent with our foreign policy interests or our economic interests. The fact that the U.S. administers that is not going to change the ability of a country subject to those particular restrictions from getting it. I mean, lots of manufacturers, other than U.S. manufacturers, produce these things. But there it's the sense of the nation that we want to make a statement. In other cases, it's actually to diminish the ability of other countries to get technologies that we find important. A really important case of that, an example of that, is how the U.S. government administers its national security sift of controlled transactions by foreign persons. So some of you may have heard about the Committee on Foreign Investment in the United States, CFIUS. And you have a recent trend of Chinese companies trying to invest in U.S. semiconductor assets. Those transactions, not all of them are the same. The semiconductor industry is a large and diverse industry. Those are particularly sensitive. So that would be a case where, yes, the United States is making a policy judgment that it's going to limit, if you will, the ability of certain parties, certain countries. Every case is a little bit different from acquiring sensitive U.S. technology, sensitive for national security purposes.
Yeah. I mean, the stated policy in enacting and enforcing all these regulations is not necessarily to punish, particularly not the civilian population, but really to change behaviors. And the crackdown and enforcement on, for example, the people who would violate the sanctions rules is meant really to apply pressure on a sanctioned country. And so, I think the government believes that, for example, in the case of Iran, that the sanctions have been successful, and that is what brought Iran on its knees to the bargaining table. But I think there's room for debate about whether or not it is preventative or punitive, or whether it really changes behavior. And certainly, in the case of Iran, we'll know in the near term.
So the companies in which you're involved, there's obviously a set of them. They're not thought of as being the center of the tech industry. Are they affected by these regulations? Have you seen this new regime of cracking down, as Mario put it?
I have. I mean, I saw it first when I was with the Department of Justice, right in the wake, as Mario said, of 9/11. Priorities, law enforcement priorities changed, turned on their head, and it was all about national security. And so I prosecuted a number of OFAC violations cases. FCPA also stepped up in terms of enforcement. And then when I went to the private sector, we see a regime of fear, frankly, where companies are so scared of running afoul of the many different sanctions that, there used to be, a time when companies would sort of want to know where the line is, and some of them, the aggressive ones, the ones who are not risk averse, would sort of go right up to the line. Here, everyone's just stays so far away from the line because the threat of enforcement and then the actual practical consequences of enforcement are devastating to a company. So we've seen a lot of that just in the few years since I've been in the private sector.
Do these laws and the heightened enforcement of them put U.S. firms at any kind of a competitive disadvantage in global markets?
Yeah,
so
they may. It's not the goal of U.S. policy to create protected foreign markets, right? If it doesn't, in the view of the government, also advance a U.S. national security purpose. They may do that. It's why the U.S. has historically tried, when administering these regimes, I think it's probably it's worth spending just a minute on what we mean by these regimes. Right? There's export control regimes that control sensitive technologies. Right? There's a sanctions regime, which essentially prohibits certain activities by U.S. persons with sanction-designated persons. There's CFIUS, which reviews foreign investment in the United States. These are all national security SIFs that regulate the cross-border flow of either goods, services, or capital. You can probably matrix it out that way. But it may very well create some competitive disadvantage. But in the estimation of the U.S. government, the policy community, there's a view that the relative national security advantage outweighs any sort of economic detriment. But you raise a good point, which is increasingly, because particularly technology markets are so globally competitive, that the ability to have vibrant export markets is actually a source of national security strength. If you think you have to innovate, have economies of scale, and if you assume, as you should, because it's the case, that U.S. overmatch capabilities are largely driven by technology advantages, then the trade-off which the U.S. government was more willing to make between security and, say, losing some competitive edge, having its domestic firms lose some competitive edge, that's more acute today than it's ever been.
And would you answer the question the same way about putting U.S. firms at a disadvantage?
I mean, I think we do feel that acutely within our portfolio of companies. We have a few companies that do business in far-flung areas of the world, and when some of the sanctions regimes, like some of the OFAC sanctions in certain countries like Iran or North Korea, which are enforced, in different ways by most of the countries in the developed world, we don't have such a competitive disadvantage. But when we're the only country, essentially, that are enforcing, that have these sanctions that enforce them, that does put us at a disadvantage. And we see that, the complaint you hear much more broadly, not just in national security issues, but in cases like FCPA enforcement, Foreign Corrupt Practices Act. The largest criticism of it is that it puts American companies in an impossible position. If you're going to be we have a company that extracts licorice root from places like Afghanistan, all the stands, and it's very hard to do business in that area of the world. We literally have like wagons that go into these remote areas and they pick the root out of the ground. It's the only way to do it. And that wagon, goes to another wagon and more is added, and that's the supply chain, that's the route. And, we have very, very strict programs in place and training and, everything we can possibly do as a company. But there's always that specter and that fear that someone somehow is going to go astray. And when you have, a lot of your competitors who don't have, some of the same rules and regulations and enforcement as we do, certainly you feel that you're being edged out.
So U.S. Officials in a number of recent speeches have emphasized, among other things, the importance of widespread international support for these kinds of restrictions if they're going to achieve their objective. I want to take the three-part division, the categorization you use, Mario, and get a little more granular. So let's look at the boycott provisions, the ones that are not focused exclusively on the nature of the assets being exported, but rather on the country or recipient of the commercial transaction. I would imagine that can't be effective without widespread global support. And if that's true, I would, and if they're therefore not being enforced absent broad international consensus, one would think that those kinds of restrictions would not have an adverse impact on U.S. firms because most firms around the world would be subject to them. What am I missing?
I think with respect to, there are essentially 6 embargoed countries today, or geographies: Cuba, Iran, North Korea, Sudan, Syria, even with the lessening of restrictions on Cuba, and also the Crimea region of Ukraine. I think with respect to all of those, you're right. North Korea, frankly, many of these countries, North Korea, I'm just looking down a list, North Korea is the subject of UN sanctions, so very few, they're just, other than China, which has been North Korea's economic lifeline, it's essentially off the global economic grid. But with respect to the other countries, many of those countries have long-standing, often benign commercial relationships. And there it's a very clear sense that the reason the U.S. administers an embargo is because we see either their regimes or the nature of the threat to the United States to be so grievous that that's a policy statement the U.S. makes. This is all, in the context of 2016 and Cuba, it's kind of hard for us to sort of accept that, but to think the Cuba OFAC program was premised on the Trading with the Enemy Act, which is a statute that was passed in a time of war, and at least in a legal sense, the basis for the Cuba sanctions program is much more belligerent, if you will, than the other sanctions program. It's almost ironic in 2016. There is some lessening, and the president has lessened a little bit. But in each of those cases, these are cases where the embargo exists almost not because the U.S. thinks it'll be effective, but because the U.S. thinks it's important to make a statement, a policy statement.
Right, in the case of Cuba, I think it's unlike Iran, which was, pretty much globally, at least, all of the big countries who, could have some effect, were also had sanctions. In Cuba, I think we were sort of out there on our own, and of course the Cuban people have suffered, but it's not, thought that it is a result of our sort of unilateral sanctions. If that's the purpose for it, that's not going to work.
Cuba, I suppose, is sui generis for lots of reasons. Its Cold War history and its political situation in the United States. But let me focus for a moment on the Sudan, just because there was a very notorious case, many of the people here are probably familiar with, involving BNPP, in which the United States ultimately imposed an $8 or $9 billion fine on BNPP and subjected it to some injunctive relief as well, because it engaged in what I understand to be rather ordinary commercial financial banking transactions with Sudanese banks, which were on the boycott list in the United States. And in France, the home jurisdiction of this bank, this was not illegal. The basis for the assertion of U.S. jurisdiction was that BNPP used the U.S. dollar-based financial system in order to implement those trades. So the question, I suppose, is if we think that widespread international support is important to make these programs effective, and we are concerned about putting U.S. firms at a disadvantage, how do we explain the application of the law in a case like that?
Yeah, again, it's a personal view. I think, first, it's interesting. The United States is often accused of being extraterritorial, right? The FCPA, sanctions, and to some degree, I suppose it's a fair statement. What's interesting is that, at least in principle, the EU sanctions regime worked in a very similar way. We don't see it from the EU as often. And by the way, it also happens to other areas of law. The UK Bribery Act, for instance, as long as there's some nexus to the UK, in principle, it reaches. It's just not it's as sweeping as US legal regimes, so there's an element of extraterritoriality, but historically it hasn't been enforced. In the case of, so that's the sort of first point. In the case of BNP, I think this gets back to your first question, which is, why is now different? I think the US, with respect to that case and some other cases of non-US financial institutions that were on the receiving end of very significant OFAC penalties, is because the US was grasping at instruments to advance its objectives. And that was the way to do it, and it could do it because they had jurisdiction, they were accessing the US financial system. In that particular case, may not have been a violation of French law, and if my recollection serves, you had instances of BNP employees stripping the identities of Sudanese nationals and then essentially submitting them to their local US-based colleagues, which essentially induced their US colleagues to violate OFAC. So I think that is well within OFAC's jurisdiction, but I think the reason those cases have been prosecuted so forcefully is this policy conundrum. What tools do we have to really put pressure on the objects of our policy disapproval? I mean, I think that's at the heart of it.
At the same time, as you were saying, you have to be mindful of that balance. If you do need the support of other countries, like France, obviously, was a big ally of ours in this. This generated a tremendous amount of upset in Europe, this and some of the other cases you were talking about. And so the United States has to be careful and mindful of not overstepping too far. Yes, it needs to achieve its policy purposes, but at the same time, you need that continued support, so you don't want to go too far. And I think it's interesting that in the first phase of the implementation of the JCPOA, one of the first things that the United States did on implementation day was to remove secondary sanctions. These are the sanctions that apply to non-U.S. persons. So I don't know how, if at all, I mean, I don't think it would have applied in this case because financial institutions are exempt from that. But it was before a U.S. subsidiary that was not in the United States and was not run by the parent company in the United States also couldn't transact with Iran. Now, there are certain rules still, certain exceptions, but by and large, the foreign subsidiary can conduct business with Iran, which is something we've been looking at for a number of our companies, being as careful as you can possibly be to get good advice from any number of lawyers to make sure that we don't overstep, but there's not a lot of guidance out there in terms of what the U.S. parent company, if anything, can do in order to sort of guide the subsidiary. So I guess it's a long way of saying, you do the secondary sanctions and the sanctions that don't seem to directly affect U.S. interests are ones that have generated a lot of controversy, and I think that the U.S. have become sensitive to that and mindful not to overstep.
Just one other point. I actually think I agree with Danya. But for these various regimes, the equilibrium is a little bit different. So in the sanctions context, because the sanctions context uniquely implicates the U.S. financial system, the U.S. has shown a remarkable willingness to push hard. And it has the power to do so because the U.S. financial system plays a preponderant role in the global financial system, just in terms of how transactions are routed. If you sort of cross the street, if you will, and look at the U.S. export control regime, there the U.S. has typically been multilateral, and probably for good reason. The U.S. in this day and age versus during the height of the Cold War, we are not so preponderant in our respective markets. I mean, clearly there are places where the U.S. leads, but even in global technology markets, increasingly there are other parts of the world that compete with us, and as a policy level, that equilibrium point is drawn elsewhere. There's a remarkable fact. In 2006, I think, a university opened in Saudi Arabia, the King Abdullah University. On the day it opened, I mean, this isn't South Korea, India, or China. Everyone knows this tremendous competition. This is Saudi, right? Not what we typically think as a U.S. strategic competitor in a technological sense. On the day that university opened, its endowment was larger than MIT's, and it took MIT over 160 years to get there. So when the U.S. considers, say, export controls and how we play in the technology industry, it draws the line elsewhere for policy reasons.
So I wanted to make that transition. I'm glad you did, but just one more comment on the boycott, the BNPP story. Yes, you're right. We can do it, so therefore we do. But I take it there's a risk that that if we unilaterally apply our boycott laws to companies whose home jurisdictions don't share our regulatory enthusiasm, simply because they're taking advantage of the U.S. financial system, obviously that's going to create huge incentives for the world to find alternative financial systems, and our power may be diminished over time. It seems to me that there's a long-term cost the United States would have to weigh. But you can comment on that. Either you can comment on that, but I want to move on. There was a question on the export control issue. The implications of what you were saying, which if we don't go it alone on export controls, and I take it the reason for that is that if we're preventing only a small percentage of the world's owners of particular kinds of assets to engage in export trade, we're not going to be hurting anybody but ourselves. The implication would be that export controls then don't put U.S. firms at a competitive disadvantage. And I'm wondering whether that's consistent with the experience the two of you have had, either in the government or now on the defense side, the corporate side.
That's more your area.
So when I served as Undersecretary of Commerce, that was our bailiwick. That's what we did, right? And so every U.S. firm that was touched by export controls would assert the position that they were harmed by it. And maybe they were, maybe they weren't. Empirically, the government statistics seem to imply that sure there was some transaction cost and some friction, but the U.S. was still dominant in the markets. I mean, I'm not an economist. I would tend to say that the government position would be that if there's any sort of cost, right, to U.S. businesses, it's really modest. I couldn't independently assess that, but that's the bulk of the weight of the government statistics on export controls.
Yeah, I mean, I don't have a lot to add to that. Those are the views, and we haven't, in my own experience, had any meaningful concerns about that or problems as a result of it.
Okay, so if export controls don't put U.S. firms at a disadvantage, obviously they cut off certain revenue channels and they impose a compliance cost. You have to have lawyers reporting to Danya who keep on top of this. But why are they a big enough deal that we're having a panel to talk about?
Well, we're not just talking export controls.
Okay, I understand. Fair enough.
Luckily for me.
I do think, I do think they, with respect to certain technologies, so for example, certain chips that have high processing power, certain encryption functionality. They may not, those technologies, and there are others, those are just certain inertial navigation systems, things that have to do with commercial satellites. You know, in the relative to the US economy, they are not particularly significant. They may be more significant in the future, but relative to the national security advantages, it's the government's view that they make sense. And that's why, at the end of the day, we're talking about them.
So let me try to put a point on that with an anecdote of a recent controversial news story. And it's in the same spirit as my comment about BMPP, which is looking down the road, what kinds of incentives are we creating for other countries and other entities outside the United States? So everybody, I'm sure here knows, at least generally, that Apple and the government have been in a bit of a standoff, although Apple seems to have the upper hand right now, with respect to what might be said to be a subset of national security interests, namely the ability of U.S. agencies to obtain intelligence about security threats. Now, it seems to me, and I don't have any inside information, I just read newspapers, it seems to me that the argument as to whether the government ought to be able to obtain that kind of information on the one hand and whether Apple ought to be able to say no on the other hand is a really interesting, tough argument. Reasonable people could disagree about it. But one thing that doesn't strike me as reasonable is for the U.S. government to have gone public with the information that it knew how to crack the code and it wasn't going to tell Apple how to fix it. And the reason that struck me as unreasonable is it seemed to me that the U.S. government, including the national security agencies, would understand that it's extremely important and in the U.S. interest that U.S. technology products not be perceived outside the United States as insecure or as vehicles for U.S. espionage, which they are undoubtedly suspected of being anyhow, and that suspicion is creating enormous incentives for, it seems to me, certain foreign countries, China in particular, but not just China, to develop their own technology products that are independent of our own, which would have certainly features we don't like in addition to the economic loss, namely they would be devices for foreign espionage. So the question is, and again, without talking specifically about the Apple case, I guess none of us really is privy to what really happened there. Are the U.S. agencies appropriately sensitive to the complicated long-term dynamics and economic incentives that some of these national security laws and aggressive enforcement of them might have?
I agree with you. I had the same reaction when, I followed that debate. I think, as you said, you could argue both sides of it. Obviously there's the privacy and the security side, and then there's the law enforcement position. And that's a healthy debate that you can have. But when the FBI, when Director Comey is testifying before Congress and making his pitch for why it is that Apple needed to essentially force, why the FBI needed to essentially force Apple to create a so-called backdoor into this technology, was because, otherwise we can't get the bad guys. We can't get the information we need. In that case, it was a very compelling case because it had to do with the San Bernardino massacre. But then to have that debate, to make that argument, and then to go undermine it by saying, well, actually, we were able to hire a hacker and we did get into it, definitely sort of broadcast a message that seemed counterproductive, at least for the stated purposes.
It certainly makes me wonder whether how completely correct your statement that the U.S. government is very mindful of these interests of U.S. industry is, at least in this case, maybe others as well.
So in fairness, just as a caveat, Kirkland has long represented Apple. We're not working on this case, so I won't comment in relation to Apple. But I think you raise a good point about how, in circumstances like the Apple case or other cases where there are really multiple risks, does the U.S. government have the capacity, the institutional capacity to weigh multiple risks, short-term advantages versus long-term, disadvantages. I think that comes up in the Apple case, comes up in some other cases. My short answer would be is I don't think it does. I think that's a lot to ask. I don't think the U.S. government has a shared whole of government unified field theory of what's in the best interest of the United States. I think you have agencies that have very typically views. They have an interagency process, but I would wish it were more organized, but it's not. It's just the nature of the thing. But I also think that on the executive branch side, career civil servants tend to be very good at identifying what, for lack of a better term, transaction risks. In the Apple case, it would be the risk of not having access to that particular smart firm for purposes of that particular prosecution. Typically, in my experience, this is anecdotal, career civil servants are really good, really dedicated, and really good at identifying those risks and the affiliated trade-offs around that decision. I think what they're less good at is balancing a transaction risk, versus a more systemic risk, which is what's implicated over the long term. And it's the juxtaposition of those two risks and that the U.S. government is institutionally not equipped to do, but is what I frankly think is the most important part of the dialogue, and what places like Stanford Law School and other academic institutions can really help.
So, well, let me turn to CFIUS for a couple more questions, and then we'll take questions from the audience. CFIUS was the third category, and as I'm sure you all know, CFIUS is a body of laws and regulations that restrict the ability of foreign purchasers to acquire certain strategic U.S. Assets or companies. You were on the CFIUS board, which is, at least on paper, looks like a pretty good interagency coordination board. Did you find that and since I suppose in your work in a law firm, have you found that the CFIUS process does a better job of taking into account the various relevant interests and having a holistic view?
So I, both as a former government person and as a private practitioner that is before CFIUS, very frequently, I think CFIUS does a remarkably good job in a job that you almost can't win. That's not to say it's perfect. I also think CFIUS has gotten better, and I think the government has been better served by having a CFIUS review process that is still opaque, largely opaque to the public because it's a national security review process, but is more transparent today than really it's ever been. So I tend to think that on the transaction risk, CFIUS does a very good job, and the sort of the backstory of CFIUS is that in the last 10, 15 years, the intel function of CFIUS in terms of getting more information about the non-U.S. parties investing, getting more information about possible risks a transaction might present, that has gotten a lot more structured, a lot more professional, and I think it accrues to the benefit of the country.
I don't know the stats specifically for CFIUS, but it's my impression that they rarely actually block a proposed transaction. They can work with them to try and mitigate whatever the risks are, but they tend to try and work with industry, if I'm not mistaken. I know there have been a number of transactions that have not gone through, maybe because of the scrutiny, but it seems to an outsider looking in that they're trying to balance obviously some different interests there, including advancing American industry. So that they don't block a lot of these transactions at the end of the day, right?
They typically don't. They don't. And actually, the popular assumption is the opposite. The popular assumption is that CFIUS is relevant only in the most sort of super sensitive transaction. Jurisdictionally, it's quite the opposite. It has broad jurisdictional reach. Very few transactions get blocked. A larger but still smaller percentage, probably around 10%, get some form of mitigation. But the unknown is how many transactions never come to fruition because people are mindful of having to be reviewed. That's the unknowable.
So if we were at the University of Chicago, being a little polemical here, we'd probably look at CFIUS and say, this ought to be ripe for industry capture, because there are potentially protected narrow private U.S. interests who don't want a transaction of its competitor to go through, or do want their own transaction for whatever to go through. Has that been a problem in the application of CFIUS?
I don't, you're the expert.
I think there is what's kind of a dirty little secret, if you will, much like in the antitrust context. Sometimes if there's a competitor, if there's a possible transaction and maybe there's a competitor to the suitor, will go to the regulatory authorities and start, making noise about the anti-competitive impacts of the proposed transaction. Some of that is starting to happen in the CFIUS context, to your point, and I can assure you that there are some companies from Silicon Valley who are, popularly known as the paragons of innovation and global competitiveness, that are the first to come in to try to probe the system and say, wait a second, there's a foreign acquirer looking at this transaction, and this transaction might raise national security risks. And clearly, they would be a competitor to the transaction. So that's starting to happen, and I think that's always a risk. I think, again, based on my experience, I think the career civil servants do a remarkably good job. But you would be surprised how active U.S. industry, including U.S. tech companies, will try to mobilize allies in the U.S. government.
So I'm going to ask one
to
more
the extent
question.
they know about a deal, because these are not public, but typically industry competitors are pretty savvy as to what's going on.
I'm going to ask one more question. In the meantime, anybody who wants to ask questions from the audience, so they'll line up at a mic, or if it's not a line, we'll take one person. So here's my question. You're on the board. You're the board of directors of a U.S. company. You're looking at this array of laws and the heightened security consciousness, politically and legally. Is this something you would worry about, or you just kind of assume that some assistant compliance officer in the company's handling it?
Well, I think what we've seen, there's been an increase in scrutiny by regulatory agencies across the board, not just in the areas we've been talking about. And so I think most companies will, the larger ones, public ones, those who, are trying to do it right, will have a much more robust compliance program than they would have had, 15, 20 years ago across the board. So, it has to come from the top down. It has to be a priority at the board level. And it has to be very much woven into the fabric and the culture of the company. Because if you just have a guidebook, a manual that is, out of date and sort of people are expected to read it when they're onboarded, that's not going to actually change behavior or culture. It has to be a real priority of the company, and that has to trickle down. There has to be real substantive training. The employees have to understand what the regulations are, why they matter, what the consequences are if they're violated. And as I said, it's got to be from the top down and just cascade down to, the lowest levels. And in my own relatively short experience in the private sector, that is something that has been beefed up, more and more. It's not letting up.
I think absolutely the board has a kind of an independent responsibility, and I think it's not enough to say the audit committee will sort of take care of this. Typically, this is not universally true. Even in the best companies that have kind of vibrant, thoughtful enterprise risk management systems, those typically tend to focus on high-frequency risks. They also typically tend to be informed by company management, often by the strategy function, which is almost, there's a bias for optimism. So I think the independent obligation of the board to assess broad risks of the company are vital. And I think I think this is an area that, particularly for tech companies that are looking to global markets, is really important for boards to be engaged with.
I understand what you're saying. This may not be a high frequency occurrence, but it could be a very devastating one if it does. Okay, spell that out. How is a tech company going to have a really grievous harm from an overlooked problem of this nature?
I think it depends on the company, depends on the value chain, depends on the exposure. But just a kind of a fairly pedestrian example, if you are, let's say, a software company, and you're a software as a service company, and perhaps you have, and this is actually a real case, so it's quite an easy example. And your delivery model is software as a service, and you utilize, high encryption functionality that's ancillary to your actual product, but it's relevant. Say you're delivering cyber solutions, but it could be other things, right? Well, if in fact you've not accounted for how the U.S. government views that encryption functionality or some other feature, and your whole business model depends upon your distributing this globally, your business can be shut down. That's a high impact event. Now, not every business is the same. There are other ways this can arise. Again, that's a pretty pedestrian example, but that's one example. I think we may have a question.
Eek, I work for that kind of company. Anyway, let's say a company in the U.S. has developed a brand new super strong encryption technology, and the government says, you have to give us a backdoor. That company's response is, we're going to sell the business to a company in Canada, so pound sand, U.S. government. What's the U.S. government to do?
The U.S. government say, before we pound sand, we have something called CFIUS. So if you're going to sell it to a Canadian company, we're going to take a look at the transaction. Now, and even though CFIUS is a voluntary filing, the government has the authority to independently review transactions. And there's actually been some interesting case law about how can Article III courts review that, much beyond the scope of this discussion. But the U.S. government has remarkable national security authority emanating from Article I of the Constitution to be involved even in private sector decisions on the basis of the executive branch is the president as commander-in-chief, and the executive branch is carrying out the president's national security prerogatives. So if the government were to say that, the government would have a lot of authority. Now, they may not have much authority to impact your business within the United States, but to the extent that your business has a non-U.S. component, government has a lot of authority.
I would, the companies with which I'm familiar, irrespective of the contemplated sale to the Canadians, which unfortunately would give the government the CFIUS jurisdiction, would say pound sand. I hope all companies would, but I know.
And by the way, I just on a thought, so what I've described to you is the practice, right? But that's not to say that there aren't important legal arguments that Doug alludes to by having technology companies sort of contested. I mean, I think if you looked at the jurisprudence, the government's got a lot of discretion in this area, but that's not to say there aren't good arguments.
I think it was a couple of years ago, there was a CFIUS investigation of an acquisition of a pork producer, right? It got a lot of attention and by a Chinese company, which struck a lot of people as a very strange application of national security considerations. I'm curious whether you think that's, I guess, sort of for anecdotal and amusement purposes, sort of what's the strangest kind of application of these kind of things you have come across where sort of an unexpected consideration of national security? And then also just, is that government regulators run amok, or are there things that we're not privy to as a general public in terms of thinking about our own national security when it comes to something like a pork producer?
Well, that was a Smithfield transaction, Smithfield Foods. And that was a fairly unremarkable case, just based on what was in the public domain. So CFIUS is an interagency body, one of the important agencies. Well, they're all important, but DHS, the Department of Homeland Security, is a significant player within CFIUS. And several years ago, the Department of Homeland Security issued a statement identifying critical sectors of the economy. And there were 16 or 18 of them. And this is, by the way, this report was issued in a way that was unrelated to CFIUS. It was just the department talking about it, what it considers important. Food supply is one of them. So when you think of food supply, a nation's food supply, the size of Smithfield in our food ecosystem, fairly unremarkable that CFIUS would want to look at it. That transaction, by the way, was approved with I think, very little, if any, mitigation, and notwithstanding a lot of public criticism. There are other transactions that sometimes they get implicated by CFIUS that have nothing to do with the transaction, but for example, the U.S. target is co-located or adjacent to or proximate to a sensitive U.S. government facility. In those cases, what's really odd is that the most sensitive facilities are not publicly known. So there's a bit of a dilemma if you're a non-U.S. buyer trying to sort of do everything sort of in a way that's upfront. But again, that happens. It comes up not infrequently.
You would think the seller would know.
The seller would know, or not, right?
Or
not. So if you're next to an Air Force base, right, you might know there's an Air Force base. But if there is a facility that is, a clandestine facility that the U.S. government uses, for any number of different things, I might be a seller. I might have a warehouse located there. I might have no idea.
So CFIUS doesn't necessarily provide an explanation for their decision, either public or privately to the...
They do not, although that's the basis. I mean, that's the basis of one of the legal claims in the litigation I alluded to, whether an Article III court can review that, and is there not a due process right to know? And basically, the answer is no. CFIUS doesn't have to give you an explanation, rarely will give you an explanation.
Have to give you the non-classified information.
Well, as a result of this litigation, they do, but they do that anyway. Actually, the litigation was settled, and the settlement is private. But CFIUS doesn't have to give you any rationale. It doesn't have to give you any rationale, right? Now, they typically do if it's unclassified.
If a defense lawyer has a clearance, would they let him see it?
They wouldn't. So the answer is no. They won't. The CFIUS will never. I mean, I have a clearance.
Yeah.
They will not give you their classified rationale for objecting to a transaction, even if you're able to have the information. They just won't.
Thank you. Very interesting discussion. Is there any rulemaking on the horizon that we should be aware of?
I'm not aware of it. I'm sure there is.
There is. On the sanctions front, it's almost, it's quite regular, right? It just depends on, just given the nature of these regimes, they're foreign policy driven. So just think in March of, let's say late February 2014, you would have thought it was fine to do business in the Ukraine or Crimea. March 2014 comes around, world changes, OFAC kicks into high gear, lots of rulemaking. That happens all of the time. On the export control front, there is an initiative to streamline the system. Whether to do that, still out, and that's sort of ongoing. But as a general rule, this is an area, because it's so policy driven, is unlike the FCPA, it's amenable to quick change. And that's actually another reason why boards should be engaged and develop their international acuity around these issues.
Erica?
We talked about BNP, and you pointed out there was some intentional conduct on the part of the company in sort of not having Sudan in the transactions that were processed. But in the work that I've done on OFAC, it struck me, especially for the Crimea, you might not know that you're dealing with an entity that you're not allowed to deal with, or an entity that has an indirect stake that you're not allowed to deal with them. So how do you see companies doing diligence around that, where it's not intentional, but unintentional?
So that was a rule that so historically, I think there's a 50% rule. So the way OFAC works, it's a highly technical piece, is that there's if you are subject to OFAC's requirements, if you're a U.S. person, you cannot do business with someone who is subject to sanctions. Being subject to sanctions actually means two things. One, it means if you're on the SDN list, especially designated, you're formally designated, and that's easy to know because if you were a counterparty and I were doing what the government expected me to do, I'd sort of put your name and address in, and if you're on the list, your name would come up, in theory. But I also can't do business as someone subject to sanctions with anyone owned or controlled 50% or more by someone who's subject to sanctions. That's the harder piece. So say I'm doing business with a counterparty that's not on the list. How do I know? That's essentially your question. How do I know? that is meant by OFAC. The answer is, in principle, you may never know. But the OFAC answer, the agency practice, is that you're to exercise due diligence. And what diligence is due in any given case, it's facts and circumstances driven. So OFAC would, as a practical matter, ask you to ask for the ownership information of your counterparty. Now you might say that's crazy if I'm dealing with the supplier in a one-off situation. That's clearly different than a joint venture partner, right? But again, there's no black letter rule, but the reason OFAC has that owned and control aspect to its practice is to essentially engage the private sector as as an extended network for its enforcement, right? To create powerful incentives for you to exercise due diligence. And that's immensely frustrating. If you're at a company, like, where do I stop? I don't have all the information. As a practical matter, if you're asking thoughtful questions, and OFAC has some guidance about this, even if you don't know all the facts and it's not egregious, right? If you're dealing with a party in Canada that has no relation, and you still can't kind of fill all the holes, and if something were to go wrong, OFAC, as a matter of agency practice, would say, did this person exercise reasonable due diligence efforts? And even if something went wrong, you'll be fine. The question is, people turn a blind eye, oftentimes. That's where it gets a little dicey.
No more questions? Any more comments from our panelists? We're done.
Thank you very much.